Good afternoon, everyone. Welcome to a LexisNexis webinar, Navigating Legal Landscapes in Digital Assets, Best Practices for Legal Professionals, where we explore legal issues for the digital assets and discover the unique legal practices for businesses involved in the crypto market. So for today, we have our guests that will be speaking in this webinar and in the panel, which include Mr. James Brockers, partner at Forsters LLP and the author of Crypto Assets for Private Clients, a Practitioner's Guide; Grace Chung, head of financial regulatory in Singapore at Gibson, Dunn and Crutcher LLP; Kylie Teo, managing partner of law firm Teo; Joshua Chu, solicitor, Group Chief Risk Officer at CoinLectables; Marvian and XBE, Senior Consultant at ProSynergy; and last but not least, we have Alfred Liu, Senior Associate from Forsters LLP, who will also be the moderator for today's session. So before we start this whole session, we'd also like to introduce a few of our LexisNexis solutions for crypto assets. So right now, I just shared my screen with everyone, and please let us know if you can't see our screen. So this platform that we have on the screen right now is what we call Lexis PSL, which is one of our practical drafting tools at LexisNexis. So this particular banking and finance module actually covers a wide range of various topics within the whole banking and finance, especially targeting on crypto assets as well. So inside our crypto assets section, we actually have not just practice notes, but also a range of key legislation articles, as well as some of the precedents and forms that you could be using when drafting various documents in relation to crypto assets. And we also have various toolkits and essential documents that you can be including in your legal research and drafting. And apart from the Lexis PSL, we also have a Hong Kong-based platform, which is called Lexis Practical Guidance Hong Kong. And this is where you'll be able to find documents related to crypto or banking and finance that are specifically drafted to be used within the Hong Kong jurisdiction. So apart from these two platforms that we introduced just now, Lexis PSL and Lexis Advanced Hong Kong Practical Guidance, we also have two other platforms, which are namely Lexis China as well as Law 360, which Lexis China is actually a platform that we have in the PRC, which is targeted for legal research, legal drafting, and analytic searches within the PRC, as well as Law 360, which is actually a legal news tracker that can be used for tracking the latest information in relation to corporate deals, crypto deals, and other legal related news sources. So thank you for listening to our short demonstration on all of the solutions that LexisNexis has to provide. So without further ado, I will be passing this time over to Alfred, who will be starting the panel discussion. Over to you, Alfred.
Thanks very much, Samantha. I just wanted to extend a warm welcome to everyone in the audience joining us today on behalf of myself and also my fellow panelists. And I just wanted to also say a warm thank you to LexisNexis for inviting all of us to talk on what is a very fascinating area that is fast developing and always changing, particularly a lot of developments in Asia, which we're all here to hear from our panelists to discuss today. So I thought it'd be interesting to first kick off with Hong Kong's recent announcement of its ambition to develop into an international virtual asset center and attract crypto firms to its territory. So Joshua, as you're the one who practices in Hong Kong, I'm sure this announcement must be very interesting and exciting for you. What are your thoughts on this announcement, and how do you think it could impact the cryptocurrency market across Asia?
Well, actually, if you look at some, this announcement actually has been long awaited. Back 1 year ago, when China first announced their interim ban on crypto trading, for those of us who are actually working closely with the government and other regulators at the time, we actually knew about the slow build up to the regulatory framework that was going on. So I still remember going against the waves back a year ago when people thought that Hong Kong was going to close off to crypto. And we emphasized that actually Hong Kong is going to probably take the lead. And 1 year later, this announcement, of course, does seem like a lot of self-fulfilling prophecy, prophetic in a sense. Now, 1 year, a lot have changed, of course. If you look at the greater markets, how the markets perform. Singapore has, of course, taken a step back in terms of being the center for crypto activities. This is largely influenced by a lot of the issues that surrounded Three Arrows and FTX. And it seems like Hong Kong is, of course, taking the lead in developing this market. And of course, with the latest regulatory framework that is coming out, we are seeing a flurry of exchanges that is coming to the jurisdiction. And so from a regulatory consultant perspective, this has been great. We advise on so far there are 2 exchanges that got the license from the previous opt-in regime. Likely there's going to be 4 exchanges. We advise on all 4 of them with alongside with law firms, of course, that we collaborate with. And it's quite exciting to see that a lot of our work is actually coming about to its fruition. So we will be seeing a lot more developments in the days to come. But one thing to keep in mind is that crypto is only a small element as part of a greater strategy in China to roll out what we call smart city concepts. Of course, I'll leave it to, I don't want to take up all the time, so I'll leave it to other panelists to chip in on these developments.
Thanks, Joshua. That's really interesting. But before I go on, so I mean, you mentioned smart cities. I mean, what can you mention just a bit more what that is exactly for some of our audience members who may have come across this fresh or want to know a bit more about it?
Well, the smart city template is actually something that has been initially championed by China, and it's actually we are seeing a number of governments all across Asia Pacific actually looking into this. We are ourselves working with people, authorities in the Philippines, in Middle East, as well a number of authorities in the region to actually put this into practice. And there are several elements that that is integrated. The first element is actually 5G and 6G, because we need data bandwidth in order to really realize the dream of having a smart city concept. Then there's the element of AI, because AI is aimed at reducing a lot of the inefficiencies we see within how a lot of the cities are being governed or benefits are being distributed. So one of the things that we have recently shared in the Philippines, for example, is that each of us are actually a member of society. However, in order to basically get our members' benefits, if you look at it this way, in ordinary lives, there's huge bureaucracy and paperwork that we have to cut through before we're able to enjoy some of the benefits we're entitled to. Then this is why having AI integrated with blockchain solutions, for example, where you have automatic settlements built in, that can speed up a lot of the benefits getting to the end users or the end beneficiaries coming about. So these are other elements. And of course, there's also virtual assets. Now, whenever we talk about blockchain, most people are focused on cryptocurrencies, but that is not the only application, of course, to distributed ledger technology. So we're seeing regulators actually going on a number of different paths of developments, both in regulatory practice as well as setting up regulations, delineating the difference between what is cryptocurrency, which has its theoretical benefits. Then there's also what we call virtual assets, which is not cryptocurrency, but digital commodity, things that intangible. Of course, the trade of intangible goods have actually been going on for hundreds of years, or well, 300 years. That's where IP trade really started, if you look at common law developments. Then there's what we call blockchain-enabled products, which is treating a blockchain more as a documentation tool that have actual substance underneath it. And that is something that's going to be very exciting in the developments, because we're seeing blockchain-enabled legal practice that will be coming about very soon. That's also in development. And these all are part and parcel of smart city templates that governments are actually racing to roll out, because it's on a political level or a geopolitical level. The first country that's actually able to attain this goal is going to have unparalleled advantage economically, culturally, and much more compared to other jurisdictions. This is why you're seeing a race, not just in China or Asia, but the entire region, on saying we are coming up with the first smart city.
Thanks, Josh. You say it's a race, and that's quite a very apt analogy, I think. There's between not just within Asia, but the rest of the world. So Grace, I mean, you do a lot of crypto work in Hong Kong as well as in Singapore, and obviously Joshua's touched on some of the contrasts between the two jurisdictions. What are your views on Hong Kong's plan to position itself as a virtual asset hub, and what are you seeing how this contrasts with things in Singapore?
Yeah, I would say that they are both in some ways quite different jurisdictions. And interestingly, I had started off in Hong Kong before I went to Singapore. And this was 9 years ago when there had been Gitcoin and ANX, and those days where you were actually changing crypto physically, at the physical location too. So those were, very early days. And to see it now and how the regime has evolved, I think right now what the SFC has proposed is still a more limited scope of the regime. A very limited scope of exchanges will be in scope. So we are working on a number of licensing applications. We previously have supported some of the players with their general crypto exchange work like OSL and Hashkey. But in general, I think when it comes to the rest of the market, I think there's a lot of interest in the wider regulated players as well. I think there's a lot of interest in crypto derivatives, market makers, and the wider range, which currently do not fall within the scope of the SFC. But you contrast it with the MES, where as I joke, everything seems to be within scope. Even a writer of crypto articles is within scope under the proposed new regulations under the Payment Services Amendment Act, where the upcoming regulations in relation to user protection would mean a more challenging regime going forward. So I think I do think it's not only what is legal and regulatory which affects the impression of a regime, but also the ecosystem and the sense of whether the regulator is supportive, what the ecosystem looks like, where the players are, where you can get talent. And I agree that right now Hong Kong is looking like, it's rising again. There's a lot of interest in Hong Kong. There continues to be a lot of interest in UAE, Saudi Arabia, and some of the other jurisdictions. So definitely, hopefully, this is a time where I think it's more important that the interest in crypto has also somewhat waned somewhat after FTX. So I think the whole industry as a whole needs some good news, and yeah, definitely hoping for that as well.
Great, Grace, that's really interesting to hear from you saying. And I mean, just going on the analogy that Joshua mentioned in terms of a race, I mean, what you're saying is that Singapore obviously is taking quite a rigid approach. Do you think Singapore might scale back a bit, ease off in order to try and at least be ahead of Hong Kong, or trying to compete with Hong Kong in this race? Or do you think Singapore is very much going to stick to its game plan that it's currently been doing?
I don't think Singapore ever set out to be a crypto hub. I think it was very much the media impression of how Singapore is portrayed as a crypto hub. If you see a lot of the schemes and regulations and projects which MES did, it was always focused on tokenization. Project Orchid, Project Nexo, Ubin, which later became Parkia, was focused on CBDCs, cross-border offerings, and some of those aspects, which I think there's still a lot of interest in, supporting supply chains, real world use cases for digital assets. So I think that is where a lot of the focus of regulations has turned towards. When it comes to digital assets as well, pure cryptocurrencies, I think there has been a lot of interest and wish that the regulators could support it as a payments currency. Sometimes a square peg round hole issue. I do personally really like the digital assets spot trading arena. But I would say that a lot also takes place in the unregulated space. So the ironic thing is that, even though the spot part is heavily regulated, derivatives trading is pretty much not really regulated at all in Singapore, because crypto derivatives that are not on the approved exchanges are just not regulated at the moment. Whereas in Hong Kong, you would need a license, a type 1 for dealing in securities, because they constitute structured products. So ironically, it's a very different position where spot in Hong Kong will be regulated, but crypto derivatives, spot is not regulated, where your OTC broker and a lot of other things, but crypto derivatives would be regulated. But in Singapore, it's the opposite. So I think players have decided to be a bit flexible on how they have structured themselves, and Singapore has grown to also take on a wide scheme and development on crypto derivatives and other types of products. So I've seen very interesting products across our desk as well.
That's great. So I think there's always, it's interesting what you say about the media perception. I think there's always a desire to try and have Hong Kong and Singapore compete against each other, but actually they can complement each other and work together, particularly in this developing market and space. Kylie, I mean, you practice in Malaysia. I'm sure you have a very unique perspective on the developments in Hong Kong and what this could have in terms of the wider Asia region, particularly in Malaysia. Can you share with us some of your views on this?
Yes, appreciate the sharing from Joshua and Grace on Hong Kong and Singapore. So I think basically, traditionally, we need to recognize that Hong Kong and Singapore are the top financial centers in Asia in the first place. So I don't think it's quite surprising that they have decided to advance and actually cover additional asset classes such as cryptocurrency currently. So I like that how Hong Kong has set up quite high goals to become the international hub and become a licensed virtual asset platform, basically. And they have set up quite a lot of requirements, such as safeguarding of crypto assets, segregation of clients of assets, and also avoiding of conflicts of interest and so on. So I think this is quite similar to Malaysia's current requirements, actually. So Malaysia, currently, we have enforced the capital markets and services prescription of securities, digital currencies, and digital token order. So previously, there were 43 exchanges operating in Malaysia, but presently, because now it is an offense to run a crypto exchange without a recognized market operator license here. So now that number has been down to 4. So seeing how Malaysia has developed all these eligibility requirements of having a paid up minimum capital and also multitude of operational risk management needed, and also client asset protection in place, I think this is quite in line with Hong Kong's growth as well. And presently, I would say actually Malaysia is quite conservative compared to Hong Kong and Singapore in that sense that our trading of the regulated digital market is really small, with an average trading of volume of 1%, which would be about 16 million ringgit or about 3.5 million US dollars on average per day. So I would say that this is quite good news that Hong Kong has decided to advance such, and also because it would be good to look up to Hong Kong to set our rules and also develop in comparison.
Thanks, Kelly. I was going to say, I mean, with Malaysia saying taking a conservative route, do you think that it may, in the years to come, slightly take a less conservative route, particularly when it's looking to Hong Kong as to how it develops? Do you think Malaysia is very much closely looking as to how that will go for Hong Kong?
I think yes, because with Hong Kong as the forerunner, I think they would be a crypto international hub, drawing in attention from all Asian countries and even European and US as well. So I think this is a great start to the road to recovery after the crypto collapse. And even its announcement itself had even raised the price of Bitcoin. So it's a good start, I would say. And previously, even Hong Kong founded exchanges like FTX and Crypto.com and even Binance, perhaps they would come back to their founding country in the future.
Great, thanks, Kylie. And James, obviously you have extensive experience of crypto markets outside of Asia. So I'm curious to hear from you your thoughts on Hong Kong's plans in the wider global context. I mean, does the territory face stiff competition from outside the Asia region?
Yeah, I think they do face stiff competition because not every jurisdiction is pushing this, but quite a few are now. So let me just say a few words on a couple of jurisdictions. Let's say, Dubai, Cayman, BVI, London, Jersey. I suppose one point to make is who are all these jurisdictions trying to attract? The crypto ecosystem is quite broad. They could be trying to attract exchanges. They could be trying to attract token issuers, maybe hedge funds or crypto mutual funds, or maybe even banks who are moving into crypto and need a more crypto-friendly environment. So there's quite a lot of different actors to attract here through different regimes. I suppose the stiffest competition will come from Dubai, UAE, but more specifically Dubai. And that's because Dubai have really been pushing this, especially since the pandemic, in a way that Hong Kong are now also doing. Dubai is really regulated in two spheres. You've got the DIFC, which is regulated by DFSA, and they introduced their regulatory regime in November. And then the rest of Dubai is regulated by VARA, Virtual Asset Regulatory Authority. And in both spheres within Dubai, you have interesting developments. I know Crypto.com is moving to Dubai, I think from Singapore, or at least looking at it and maybe looking to apply for a preliminary license. So they're really pushing it in Dubai. And I think some of the actors that they're trying to attract there, such will be things like exchanges, virtual asset service providers, lending, brokerage, all of this kind of these kind of services, hedge fund perhaps. So there will be a lot of competition there. In places like Cayman, BVI, Jersey, I think they will adopt a slightly different approach. I think they will probably try and attract more token issuers. So Cayman has been really leading on this. If you look at Cayman, they've been doing a lot of DAO activity, decentralized autonomous organization, which for anyone who doesn't know, a DAO is basically it's a crypto business which is run by the token holders. They vote on how to advance the project. So Cayman's really taken a lead on that. And Cayman does have a VASP regime, so that's a regulatory regime for crypto. But so do the BVI, and the BVI have actually taken quite a different approach to Cayman, because in BVI, token issuing activity is not regulated within the VASP regime. So what you often see in terms of structuring, you might see a Cayman foundation for a DAO, and then the foundation might hold shares in a BVI company, and the BVI company is issuing the tokens. And then you've got places like Jersey who are doing a slightly different approach. They're going for a very, very blue chip type approach. They only want to look at blue chip projects. And then, of course, don't write off London, where there's a lot of hedge fund advisory and custodian work for crypto. But I think a lot of it will come down to having the right regulatory regime, having the support of the banks, that's crucial, but also attracting personnel, because some of these actors will require a lot of labor, especially things like exchanges. So I think that will be key. So, but I do very much see this as, I think the main competitor will be Dubai, if I had to say one.
Thanks, James. Well, I think I can speak for those in Asia. I think it's great that Hong Kong is stepping up and being the beacon from the Asia side, and hoping to compete with other global jurisdictions. I mean, it's really fascinating hearing from all of you about your expertise in this digital asset legal advisory space. I think it'd be invaluable for a lot of our audience to hear from each of you your complex legal issues around crypto assets that you are advising on and seeing clients facing. Before I move on and ask some of the panelists questions in this area, I would like to invite people to ask any questions in the Q&A function chats, which we will pick out at the end of the panel discussion. So please do feel free to ask any questions in the Q&A chat function when you get a chance. So James, from my own experience as a private wealth lawyer in Asia, there's a huge thriving trust and fiduciary industry here. And with the advent of cryptocurrencies and crypto assets, it's raised a lot of challenges for fiduciaries and trustees in recent years. So from your perspective as an international private wealth advisor, can you talk a little bit about structuring crypto assets held in trust and what trustees should be thinking about?
Yeah, I think this part of crypto will grow in the next 5-10 years as crypto holders well, first get older and start to look at things like succession planning, but it's also about asset protection as well. For many reasons, asset protection is important when it comes to crypto. So that they're anxious and they do want to structure, but the trustees are also anxious. And the reasons are, I think, threefold. First, that you have compliance issues. Taking on crypto is not an easy thing to do. Obviously, trust companies have to go through enhanced due diligence. But there's also the practical issue around custody. Who is to hold this asset? Because really, as we'll get on to, crypto is property. We've seen that, so it can be held in trust. But who is to hold the asset? That very often means who is to hold the private keys. I've seen in practice trust companies take two approaches. First, and probably the best and best practice approach, is that you appoint a third-party custodian to hold the asset for you. That comes with costs and implications. The trustee should be reviewing the custodian. Or you could get the settlor, the creator of the trust, to hold the asset themselves, if you can get comfortable with that and have a custodian agreement with the settlor. So different approaches, but it's a very difficult thing to grapple with for trust companies. Another aspect, of course, is the volatility of the crypto markets, which really conflicts with what trustees very often try to do, which is to be very sensible. In trust law, we have the prudent man of business rule, that trustees will invest as a prudent man of business would. Would a prudent man of business invest in purely speculative tokens? Who is to manage a crypto pot within a trust? Can you get the settlor to do it, or can you appoint a third party? And if a third party, who is to do it? There isn't an equivalent of a private bank, as far as I'm aware, who are able to offer a very conservative approach to crypto. So there are definitely investment challenges. Of course, the trustee could seek to exclude or try to mitigate their liability through anti-Bartlett clauses. In Hong Kong, there was the Zhang case, of course, so this is very topical at the moment, but trustees can seek to mitigate their liability by holding crypto through an underlying company, and in the trustee purporting to relinquish control as far as possible. But these are the challenges that trustees face.
Thanks for sharing, James. And I think that's the thing. I think it's a lot of it is from the trustee side. A lot of the challenges are risk mitigation and risk assessment. And you mentioned, when it comes to the topic of trust, about whether crypto assets are property. And there's a recent case, the Gatecoin case in Hong Kong, which declared that cryptocurrencies were property and could therefore be held on trust. So no doubt this is, for trustees, this is quite a reassuring judgment, because with risks, there's always, with crypto assets as an asset class, there's always potential disputes. And I mean, Josh, turning to you, I mean, you have a practice in disputes and digital asset disputes in particular. I mean, what are you seeing from this area, and the best practices or worst practices that people can take away from this? There's
actually quite a few layers, of course. Of course, we have seen a lot of recent announcements saying Gatecoin's the judgment was the first judgment to recognize as a property. But in reality, Hong Kong's court actually has been dealing crypto as a form of property in a number of proceedings. But of course, a lot of them don't actually make it in published judgments, because judgments are just delivered orally, as well as there are a number of court orders that actually have been touching on these issues. I still remember doing back in 2016, when I did when I represented Bitfinex at that time, we were able to, one of the key issues we were dealing with is actually about how to freeze certain crypto assets at that time already, and a very innovative way of doing it at that time. The key problem, of course, that we're seeing practitioners having to deal with when it comes to these sort of issues is not being able to basically explain to the court the whole mechanisms as to how to draft a proper court order. That's something that a lot of practitioners have struggled with. I had an advantage of being an IT professional before becoming a lawyer. Hence, I still remember when back in the day when I was explaining it to the courts, one of the criticisms I have gotten is actually I was actually touching on areas that should have been done by experts. evidence instead of a lawyer doing it. So there are these lines that you have to navigate across, of course. But even back in 2016, there are actually precedents as to how to basically handle these matters. Then there's the education of preservation of assets, as James has already pointed out. And one of the things that we have done is you have to basically know how to delineate what is the best course of action. Should it be through the courts or should it be through law enforcement? I still remember one of the early days cases that we have done is we work directly with Europol, which is basically really European equivalent of Interpol, and we're able to actually tag these what we call contaminated crypto, which eventually assisted us in recovering 100% of all the cryptos in questions. In the case, I couldn't delve into too much details, of course, but education is a very huge issue when it comes to virtual assets. And the problem we have been seeing is that it's not something that's taught in law school or anything. And so it's really up to practitioners to really take a deep dive as to what to do next. That is why one of the things that we have been doing is I'm also the co-chair of the blockchain, the Web3 Association of Hong Kong. And one of the key things that we are actually pushing for is education of the public as to basically understanding what these technologies are and how to properly and responsibly implement them. And that goes the same for lawyers, because having the ability to articulate to the courts as well as in applications as to what you're trying to do is very important. And that's the biggest gap we're seeing right now.
That's really interesting that you say actually education is always key, and actually one of the reasons why we're here talking to our audience members, just to help raise awareness and a bit more education in this area. You talk about the courts. I mean, do you think the courts are, I mean, when you mean practitioners having to articulate some of the concepts to the courts, do the courts inherently have some understanding themselves, or is it still very early days for them to still understand and relying on practitioners to educate them on these issues?
Of course, as a disputes lawyer, one of the things that I notice a lot of lawyers do not do is they just simply do a very two-dimensional approach and throw an application out there, and basically is playing what I call litigation roulette. Having your case fixed before a judge that actually knows how technology works makes a huge difference, but unfortunately not a lot of practitioners does it, either because they don't know who to turn to, and more importantly, they don't basically, it's not something that you learn in school or anything. We do have judges. One of the underlying objectives of the legal system in Hong Kong is actually the promotion of the use of technology, and that's and we do have judges that are very keen on pushing that. For example, one of the things that, as a result of the civil justice reform, is that alternative dispute resolution is supposed to be a way that you don't have to use up the court's resources. Yet in every single arbitration case, we see so many people wasting time and resources on enforcement proceedings, which if you had, so one of the recent papers I've done actually is, or I have actually explored this with HKIAC last year, is if you have arbitral award that is actually handed down using smart contract as a feature, a smart contract enabled arbitral award, where the winnings and damages can be allocated to tokenized assets. You can truly have a true ADR within the space without ever having to set foot in local courts. And that will be revolutionary, not just for jurisdiction per se, but the entire legal practice in the days to come.
Thanks, Josh. That's really interesting for you to hear. And I think, I mean, just continuing on the theme of risks with crypto assets for the time being, I mean, Kylie, what are you seeing, and what do you think there are lessons that can be learned from failures such as the recent collapse of FTX? I mean, you talked about that, well, you kind of touched on it very briefly. I mean, interesting to hear your views on that.
Yes, okay, so for context, FTX used to be one of the largest crypto exchanges in the world and collapsed last year in November. So to simplify this complex world of crypto, basically it just boils down to two main points why it failed. So I think it will be weak governance and legislation to counter, and also like what Joshua mentioned, education as well. So I think the awareness for investors and risk management of the investments were pretty weak at that time. And so on weak governance, I would highlight that it is understood that emerging technologies, law needs to catch up actually. So with new laws, sometimes it can't catch up with new developments in technology. So I think investors need to take time to understand that sometimes the law does not cover any redress, in fact. So and need to realize that preventative laws may not always be in place in the first. And also depending on the country and the DAX, which is the digital asset exchange which you are operating in, they may not even be laws in place in the first place. So yeah, I think this needs may lead to actually withdrawal issues in the future, and also freezing of assets, which investors may not even be able to take action on. And also, yeah, fortunately for Malaysian DAX operating in Malaysia, so those DAX are obliged to segregate their clients' accounts from the operator's own money. So in the event that the operator is subjected to liquidation, so it will be easier for the Securities Commission to identify the money of the investors. So I'll move on to the awareness of the investor. So yeah, basically, like I said, cryptocurrency is still quite fairly new in the law. And actually, all the world laws are still developing. And in fact, I think there's not much similarities to some. In fact, some may cover certain laws, some may not. See, so, and the landscape is ever changing. As such, I think it's quite significant to prioritize on being updated with the latest news in your country as an investor. And yeah, one complex issue which I would like to talk about as well is the interconnectedness of crypto laws with other areas such as even contract laws and jurisdiction of the courts, and even alternative dispute resolutions, like what Joshua mentioned as well, which is arbitration. So investors need to evaluate the legal risk that involves between the user agreements that's not to say signed, but rather agreed through the platform with the DAX. So yeah, you have to look through the user agreements, the legal currency transaction rules, the privacy policy of the platform before really delving in deep with your investment monies. So yes, on top of that also, you have to look through what kind of legal recourse and remedies are there in event of future disputes, and how do you solve the problems when problems arise. So basically, one of it that Joshua mentioned, which was good, is arbitration, which is a good form of dispute resolution besides the court, because it's just similarities towards the crypto world. Actually, it's confidential in the sense that yeah, both prioritize confidentiality, because to the extent that documents, evidence, and awards, how the extent of which to be disclosed to third parties is quite limited actually. And also it involves a neutral third party for arbitration, which aligns with the fact that the decentralized nature of crypto helps as well. And this is along the line of the applicability of being in multiple jurisdictions for the awards as well. Yeah. So yeah, I would like to conclude by saying how Christopher Hui from Hong Kong, the Secretary for the Financial Services and Treasury, pointed out that crypto exchanges are similar to stock exchanges, but yeah, he did not point out the risks, such as the anonymous nature of virtual assets may lead probably to money laundering. But I think he's aware of such. And yeah, there is further gaps in the similarities of this crypto, and it's ever changing, like I said. So the risks are, it's full of limitless possibilities for risk, but also limitless possibilities for opportunities, I would say.
Thanks, Carla. I would agree. I mean, there's always good to be optimistic in a lot of cases. And I think we're touching on, obviously, talking about risks and the response of governments to risk is invariably increasing regulation. I mean, we saw this with the 2008 banking financial crisis. I don't think the crypto and digital assets industry is immune to this. So, Grace, I mean, can you talk about the regulatory considerations anyone operating in this space should be mindful of, especially from a cross-border perspective, especially when so many jurisdictions seem to be taking different regulatory approaches, especially within Asia?
So risk on its own, it's not new to the financial services industry. And I think a lot of the people that we see in the digital assets industry also came from traditional securities, traditional backgrounds, where they do understand that to put forward the best proposition as an institutional entity, that they do have to manage operational risk, liquidity risk, market risk, and other types of risk well, together with AML and other types of anti-bribery and sanctions risk vis-a-vis their customers and their business models as well. In fact, sometimes when I look at some of the issues which the regulators are looking at with regard to user protection and whether they should permit lending, staking, margin lending, and suitability tests, which is being considered across both Hong Kong and Singapore. I think back to, as you said, the 2008, 2009 times, and when I first returned back to Singapore and joined the Monetary Authority of Singapore, I had landed straight to the time where MAS had been working on the Lehman Mini Bonds report, which many of you will be familiar with, where at that time, despite the fact that these products were regarded as generally safe at some point in time because they had exposure to what was regarded as gold standard financial institutions, the complexity of such products also meant that in terms of the leverage, in terms of the exposure of counterparty risk, those were risks which even professional investors may not usually be able to grapple with, given the complexities of structured products. And I think this is what regulators have to struggle with, because given the evolving nature of digital assets and products, you can't just be looking at a square peg round hole kind of situation. And similarly, for example, the MAS has sought to regulate digital assets by considering how it can be fit within the payments regime. And therefore, we saw a lot of issues in considering how digital assets can be seen as payment tokens, because in reality, a lot of digital assets are not really payment tokens in nature. In Hong Kong, I think the difficulty there is that the regulator has been seeing a lot of the regime on the basis of the Type 7 license, the automated trading engine, when in reality, as I've noted very interestingly with the regulator, none of the exchanges which are operating in Singapore today will qualify for the Hong Kong licensing regime today if you're looking at the scope of the regime, because the Type 7 type thinking is something which is more suitable for securities compared to digital assets, given the efficiencies and the liquidity of how digital assets just has evolved in the market. So I do think that sometimes when it comes to regulations, when it comes to risk, you can never go back at a point in history and operate from that time. You have to keep evolving and keep thinking and learning from the lessons of history. And I appreciate that a lot of very talented people in the industry are working on these very innovative questions as well.
Thanks, Grace. I mean, I think, to be honest, I think given the time it is now, we could really be talking for hours on this topic. There's so much interesting content to cover. But I thought, I mean, I think I'll jump to the final question for you, or just to make sure that there's some time for some Q&A at the end of it. So as advisors, it's always good to be forward thinking. So I'd like to kind of finish off the last question by asking you, what do you think the future holds for digital assets across Asia? Perhaps Grace, why don't we start with you? What do you think on this topic?
I like the idea that given the efforts of governments on blockchains and cross-border attempts, what can traditional financial institutions do on those blockchains, and what is the future of that? So I like the idea of what is the future for institutional blockchains. Yeah.
Thanks, Grace. And how about yourself? I mean, how about you? Do you think the future is bright, or do you think there could be some dark clouds ahead in this in Asia when it comes to the development of digital assets?
Yeah, I definitely always think the future is bright. That's why I continue to work in this area. Definitely, I do think that the regulators are supporting a lot of these attempts, which is helpful. I think open engagement always helps. And I think that there are a lot of companies which are also evolving on their business models. So I think definitely we will continue to see a lot of companies evolve and find the next big thing. I think a lot has been focusing on AI and some of the new changes. I see a lot of new things happening in the field of products. yeah, I mean, if you're looking at 8 years back, I did not expect a lot of the changes on what we see in the stable coins, for instance, and what we see today on AI. So I think definitely the future is bright. And for lawyers, we definitely have a lot of opportunities to grow and expand and just grow as, in the way we work with others in the industry as well. Yeah.
Thanks, Grace. And how about you, Joshua? Do you share the same optimism that Grace has?
Well, I have to because I'm within this industry at this time, so I can't say anything bad about it, I suppose. Now, that having been said, we are seeing, because we are working directly with governments, not just private enterprises. So we are in the business of setting the standard as to how these technology are applied responsibly. So you're going to see more and more application, and we're seeing more and more integration within our society, especially with the smart city concepts that's being rolled out. And this is something similar to what the internet went through. I mean, one of the jokes I said is, thank goodness that the value of the internet is not tied in with the stock prices of the first internet companies. Can you imagine if your internet value is tied in with AT&T? I think that would be quite sad. Reality is that it's always about application, and the problem with new technology is that there's always a lot of hype because people do see the potential, but there's a chaos when it comes to people not knowing about how to apply it. And we're seeing multiple market corrections. Each time, after each correction, however, we will see that the industry become more and more mature. That is why I said early on, the regulators, governments are all waking up to the fact that it's not just about virtual assets, it's not just about cryptocurrencies. There's actually three categories, which is cryptocurrencies, which is also a category of virtual assets. And there's virtual assets, which means nothing tangible, but representative in what you see nowadays, digital commodities. And then there's just simply what Kaylee said earlier, as well as Grace have said earlier, which is what Singapore has been focused on, real application of blockchain technology in tangible assets. So this is exemplified by some of the things that our company does, which is we have used blockchain technology to apply towards traditional arts and collectible auction, mostly in the form of provenance. And one of the unique things that we've done that hasn't been done across industry is we have actually placed the title deeds within the tokens themselves, meaning that the tokens for the first time in history have something of substance underneath it, in which case traditional common law principles already apply. You don't need new rules to apply each time there's a new technology. This is another blind spot we see in a lot of practitioners. They tend to freeze up and say, I can't find a case precedent that address this issue. Now, as a litigator, I'm a bit of a glory hound when I was in a private practice, and I love establishing case precedent. So whenever I get excited when I don't find a case precedent, because it's like, oh, this is an opportunity for me to convince the court to basically apply new principles. And it's great because there's no opposition this way as well. So it's two sides of the coin, and we'll see a lot more developments in the days to come. And that's one of the reasons why I enjoy doing technology law for the longest time, is because this is where you can actually leave your mark in history. Not to say anything bad about other traditional practice of law, of course, but we will see more and more of that exciting things happening, not just in Hong Kong, Singapore, or even Dubai. Dubai is a great jurisdiction. I was just there last month, meeting with the sheik there. They offer 100-year loans, so it's not just the regulations that's very attractive. It's actually the business environment as well. That having been said, we will see that it might surprise some of you 1 year later to see some countries that are actually very invested within this space that might come out on top, even potentially ahead of the big players. And that's something that's great about emerging technology. It gives opportunity, not just for businesses, but actually for entire governments. Because if you can create a new financial sector, which doesn't exist in any other jurisdiction yet, you might actually see a country that might be considered less than developed today becoming a financial center 5 years down the road. And these are the exciting opportunities that we find on the geopolitical level as well.
Thanks, Joshua. As we keep saying, I mean, there's that old adage, you know, where there's risk, there's also reward, and so definitely that would apply to this this market. I mean, Kaylee, what are your views? Obviously, there's always a bit of skepticism when it comes to digital assets. Do you see that mindset changing anytime soon as the market matures, as Joshua mentions, and if you do see it change, I mean, do you have any time frame as to when you think that could happen? Or we don't have a crystal ball, so we won't pin you to the mast on it, but any thoughts from you would be welcome, I think.
Yeah, I quite agree with Joshua that I think it takes time to mature, but I think we're on the way there as a country, as a whole, as Asia. So I think, but a caution to investors though, I think it's good to look at the bad sides as well. So I think I would like to caution that no laws are perfect in the first place. So I think it's good to look through whether there's possible breaches of data, whether there's manipulation in fast trading, tampering of app connections when prices surge for cryptocurrency, and also even unilateral blocking or deletion of users from the platforms itself. So I think if our laws can counter those, I think it'll be a much better world that protect private investors as well and retail investors. So I think the outlook is looking quite good because Malaysia has started to explore the potential of a central bank digital currency, which is a CBDC. So it's working with Australia, Singapore, and South Africa. So maybe I might come into Grace one day too. Yeah. So and I know for a fact that BIS Innovation Hub, Hong Kong Center, they are working towards a CBDC as well with Thailand and China and UAE as they call it mBridge, which I think Joshua can perhaps talk about.
Well, I think I'm not at liberty to delve into that topic because I'm actually working on some of those projects.
Oh, okay.
But that having been said, I would like to, I think if you're saying what is a takeaway point for anyone in terms of mitigating risk, well, I'm the only one not in private practice at this moment. So I think all the audience can hire any of the panelists here. That would be a great opportunity, way of saving us, mitigating a lot of the risk. The panelists can of course engage me back in the process. But thank you so much for the discussion, of course.
Yeah, thank you, Joshua. I think I'll just like to end that. I don't think we can stop tech developing, but we can move towards a more synchronized world in terms of legal coherence. Yeah.
Thanks, Gary. And James, I'm finally telling you, I mean, what can you tell us? What do you think? Hearing from your fellow panelists on thoughts about the future of crypto and digital assets across Asia. I mean, how do you think it compares to your thoughts on this when it comes to other jurisdictions in contrast?
Yeah, it's been very interesting because a few years ago, Hong Kong was clearly in the mix and then it wasn't, and now it is again. So now I've heard from Joshua and I can see that has been all that time. It has been a thought process. I think the opportunities are there. When you look at the institutionalization of crypto that is ongoing, family office, private banks, hedge funds coming into the industry. But in terms of lawyers, I think there will be, in private practice, as we say, there will be great opportunity. A lot of the litigation has been against exchanges, but I think that will broaden. If you look at the Tulip trading case in England, that's against the developers of the Bitcoin network. So that's an interesting case. I think there'll be more divorce cases, more commercial disputes, but ultimately, I think the success, what will be key to Hong Kong's success will be common law, with the flexibility that is inherent in the common law. Because if you look at all the challenges thrown up by crypto, for example, that it doesn't necessarily fit into the category of chosen possession or chosen action, the common law has been able to accommodate it. Smart contracts, it's been able to accommodate, not in any cases, as so far as I'm aware, but smart contracts, I believe, will be accommodated within the common law as well. So the legal principles will need to be flexible. Of course, it will need to be regulation, but in terms of navigating through, a little bit of flexibility in the common law will help. So, but I'm an optimist ultimately.
Thanks, James. Well, I mean, I think it's really good to end the panel discussion on a high note, on optimism. I'd always like to end all panel discussions that way. That's been very good. So thank you for your time. I think we've got maybe a time for a bit of Q&A. So there's one question that's come through, and actually it's something that you touched on Joshua, in terms of advising on mitigating risks associated with cryptos and cross-border transactions. I mean, with my own lawyer hat on, I would say obviously we're not giving advice here on this panel, but we can give some tips and things to think about. Let's given Joshua that you mentioned this briefly, do you have any thoughts as to this question of risk mitigation in this area? Just some key, maybe a takeaway point for the audience to go away with.
Well, having worked in both tech and law by this point, so I think for any projects that you want to actually see successful, there are three pillars that must be satisfied. The first one being finance. Without finance, you can't really get very far. Then of course there's the tech, and then finally there's the law part. A lot of the tech companies, they do not focus on law at all. So that's why they're running into a lot of trouble. Of course, right now, recently I've actually, surprisingly, I decided out of the blue to join the Techathon competition here in Hong Kong. And my team ended up winning, even though we only spent like a week on coming up with everything. And one of the things that we've done is how to use AI to make regulatory and legal advice more facilitative and capable. And this is something that is going to basically change a lot of the style dynamic. Of course, the lawyers will never be replaced by AI. Well, it's quite clear. It's always about how you can properly apply it. So engage a lawyer is the best way to basically avoid risk. Advertising for all my fellow panelists here. This is the best way to do it.
Thanks, Joshua. And I mean, we've got a couple of minutes left, so maybe if I ask the same question of Grace, I mean, what are your takeaway points in terms of risk mitigation for any audience members in the crypto asset space that might be interested to hear from you?
Sure. I think I'll add 2 points there. One is that from the viewpoint of risk, so we work on some tokenization projects, like tokenized security or tokenized bond projects, where we are starting to think more precisely about some of the disclaimers or some of the mechanics of some of these projects in light of counterparty risk, in light of how things may evolve in the market, and cross-border offering considerations, given US and a lot of other aspects. So I think risk is something where on a cross-border offering basis, you are starting to see a lot of complexities. And I think in this area where in the past it may have been safer to really focus only on one jurisdiction, I think a lot of entities are now looking on a global kind of offering, which means that the risk now has to be looked at on a very specialized manner, looking at key jurisdictions where you're offering some of these products as well. The second part is corporate governance. So I think there's a renewed focus on corporate governance in many jurisdictions. In the jurisdictions where I focus on, Singapore and Hong Kong, as you know, there are a key focus on the individual accountability and conduct regime in Singapore and managers in charge regime in Hong Kong. For example, in Singapore, we have heard from the regulator quite clearly that not only must you have people who are managing risk within your organization, but you have to have a clear setup and reporting lines and a clear way of ensuring that these people do not have conflicts of interest and are clearly set up, given their expertise, to manage the key areas for which they cover. We had one very interesting case, for example, where the head of risk and compliance was covering two other regulated entities, i.e. they were also working for 3 payments entities at the same time. And the regulator said that, it showed that the entity was really demonstrating that it did not have oversight because the employed person was moonlighting for 3 entities and was inclined to reject their licensing application. We are starting to see this across a lot of the entities for which we support, where the regulator is focusing on ensuring that the responsible officers, the head of risk, the head of operations, the head of compliance in particular, does not work for any other entity and only works and devotes oversight for only one entity. So even for consulting companies that they use, specialist help that they use, if such outsourced support is supporting more than a certain number of entities, the regulator has challenged whether sufficient oversight is provided. So I think these are important an important focus on corporate governance and oversight in both Singapore and Hong Kong is what we have noted. Yeah.
Great, thanks, Grace, and thanks for sharing that. I think we've kind of come to our time. I mean, as I said, we could probably talk about this for hours on end, but Kylie, Joshua, Grace, and James, just want to say thank you for a very insightful, very lively discussion on this very fascinating and fast evolving area of legal practice. I think the takeaway points for anyone in the audience is get advice and make sure that you're educated, because this is clearly a very complex area. So thank you for LexisNexis for organizing this, and thank you for those in the audience who took the time to listen to us today. Thank you.
Thank you.
Thank you.
Thanks a lot.
Thank you.
Thanks a lot, Alfred, and thanks a lot for all of our speakers for speaking at this webinar today. So this would conclude the whole webinar, and if you have any questions, please feel free to reach out to any of our speakers or reach out to LexisNexis, and hope you all have a great day. Thanks, everyone.